and thank you for joining us. We're going to spend some time today talking about the E-2 visa requirements and also look at E-2 visa renewal considerations. A few things before we get started. So some of you may know the firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is here personally on an E-2 visa, so is very familiar with what E-2 visa applicants are going through. The firm is a full-service immigration firm, but we focus primarily on E-2 visas. We've processed hundreds of them, and we typically process E-2 visas that are higher risk, meaning kind of lower investment amounts. We processed at many consulates all around the world, but our primary two consulates are Toronto and London. We will continue this webinar series, doing at least 2 webinars a month on different topics. Also, at the end of this webinar, we'll send out a few things. So this PowerPoint that you'll see today, an E-2 visa guide, which is a comprehensive guide to the E-2 visa elements, a link to where you can sign up for additional webinars as well. For our panelists today, we're lucky to have Dustin Saldariaga, who is an associate attorney at Scott Legal and has processed many E-2 visas. My name is Kelly LeGrand-Wiener. I'm the managing attorney at Scott Legal and will also be speaking in the later part of the presentation. If you have any questions during the presentation, please send them through the chat box and we will try to address them if they're relevant to the topic, either as we go, or if not, we'll get to them at the end of the presentation. Finally, this webinar will be recorded and made available upon demand. So without further delay, I will turn it over to Dustin to start the presentation.
Great, thank you very much, Kelly, and hello everyone. Thank you very much for joining us today. So we'll start this presentation by going through the basic E-2 visa rules and regulations. What is the visa and how do you get one? And this list you see on the screen is really background. We'll get into some of the more specific requirements in some later slides, but the Treaty Investor Visa, or E-2 visa, is a non-immigrant visa that allows nationals of certain countries to come to the US in order to develop and direct the operations of a business in which they have invested. So there are 3 main ways that our clients tend to acquire the business or start the business that they'll be coming to the US to develop and direct. Typically, people are starting a startup. They're starting a business from scratch by investing into that business and growing it from the ground up. However, there is the option to purchase a business in the United States and invest that way. And finally, a popular third option that we see quite a bit is for clients to start a franchise or to purchase a franchise. Whether that is a sandwich shop or a junk hauling business. All 3 of those are viable ways for foreign nationals to initiate the E-2 visa process by starting or developing a business. Now, I said before that the individual must be a national of a certain country. That's because the E-2 visa is a treaty investor visa, so it's only available to individuals who have a passport, who are nationals, from a specific list of countries. And these are countries that have a specific treaty with the United States to conduct trade. The list is long, so what you can do if you want to make sure that your country of nationality is on the list is you can go to the US Department of State website, and you can even Google US Department of State E-2 treaty countries, and you'll see a list of about 80 countries. These countries are on at least 6 of the continents, including Europe, Africa, Asia, Latin America, and the Middle East. So odds are that for most people who come to us, this is not an issue. However, 2 countries that are not on the list are India and China. There are ways for nationals of India or China to acquire an E-2 visa. We won't be going into much detail on this, but I just wanted to share it so you're all available if this is relevant to you, that unlike a green card in the United States, what is relevant is the country where you have a passport from, not the country where you were born. So it is possible to acquire citizenship in another country, say through investment in that country, such as Grenada is a popular option we see, to get a passport from that country and to pursue an E-2 visa. Finally, on the list you see, for how long is my E-2 visa valid? The range of time is quite broad. So the shortest amount of time that you can be issued an E-2 visa typically is 3 months. And the maximum length of time is 5 years. And what really determines that is two things. First of all, there is this idea of reciprocity that if the treaty country limits the period of time that US citizens can acquire a similar visa in that country, then the US will reciprocate and similarly limit the time. That's the first limiting factor. The second limiting factor is the nature of the application. If in the application, it doesn't seem like the business actually requires 5 years, or if this is a startup that the consulate for some reason thinks they want to see the person within 5 years, make sure that the business is actually viable, is actually getting traction, then the consulate might issue the visa for less than 5 years. It's important to distinguish the visa validity period from the length of status. So they're two completely different things. The visa validity period is the window of time that you have to enter and exit the United States. The status period is the period of time that you can stay in the US after you enter, or on each entry. So for example, let's take an extreme example. Let's say that you were awarded an E-2 visa for the minimum 3-month period, and you decide to enter the US on the last day of that 3-month period. You would typically be granted, even though your visa is now, at the last day of its validity period, you would typically be granted 2 years of status in the United States. So you'd be able to stay in the US for 2 years while you develop and direct that business. Now, as soon as you leave the US, because you would no longer have a valid visa, you'd need a new visa to re-enter. But I hope that example kind of helps to clarify the difference between a visa validity period and a period of status. So let's go a little bit deeper into the E-2 visa requirements. As I mentioned before, there are really, if we think of the 3 typical scenarios that we see, whether it's starting a business from scratch, purchasing an existing business in the US, or starting a franchise. You can see, if you think of those scenarios, you can see how each of these requirements might apply. So the first requirement, I'm sorry, let me share that again. The first requirement is that you must make an investment in the business. So you have to actually commit your personal funds to the business. Those funds must be at risk. So what this means is that they actually have to have been spent on the E-2 business. It's not enough to, for example, simply transfer your personal funds into a business bank account in the US and submit an application by saying, look, consular officer, I have $1 million that's in a business bank account. Therefore, I've satisfied the investment requirement. The consular officer would say in response that actually those funds are not, quote unquote, at risk. They haven't been committed to the business. And what they'll want to see is that those funds have actually been spent on a variety of things that are needed for the business to be operational. So you see a couple examples here in the 4th slide down the screen: inventory, equipment, developing a website, spending money on office supplies, an office lease. These are all key examples that we consular officers are used to seeing money being spent on, and that when individuals come to us for help and we look at the list of what they've spent money on, we tend to look for things like this. I want to quickly say there are kind of 2 aspects that the consulate is looking for in the investment, and we'll talk a little bit more about these. The first is, like I mentioned a moment ago, the consular officer wants to see that money's been spent on the full variety of things that are needed for the business to be operational. So they're looking for variety. The second thing is the investment amount. We'll talk about this in a later bullet, but the officer wants to see that enough has been invested in the business to, first of all, show that the applicant's committed to the business, and second of all, to show that the business is ready to be operational. The source of funds, this is the second sub-bullet here that you see on the screen. The funds that you invest into the business must have been acquired lawfully. This is actually a quite low bar when you apply at a consulate. Usually consulates don't spend a whole lot of time looking at this, especially if it's fairly clear where you got the funds from. If you got them from working, for example, you would include tax returns and maybe payroll records. If you got the funds from a gift that someone gave to you, which is perfectly fine, then you would include a gift letter, for example, a letter from the person who gave you the gift, as well as a document showing where they got the money. If you sold a piece of property, like an apartment or a home, then you would want to include in your application documents showing that you own that home, that you sold it, and funds arriving in your bank account. Again, at a consulate, they're not going to actually dig deep into these documents. As long as they're satisfied that these funds were acquired lawfully, the questions usually don't go past that. If you're applying from within the US through USCIS, then the USCIS does take a much closer look at the source of funds and will actually want to do an accounting that traces essentially each dollar that's been invested in the business. The investment must be substantial. We'll talk about this more in the next slide, so I won't say much more about it now, but this gets to the overall amount of the investment. Again, we'll talk about that in a moment. And the final sub-bullet under part one is the investment amount is considered differently when you are starting a business versus purchasing a business. When you're starting a business, it may be difficult to show the government that you have actually invested enough to get the business started, because this is a business from scratch. And so it is important that you show the government that, you know, for your type of business that you're starting, you really have put enough money into it to get it off the ground, to get it operational. What we would often do is, if this is a business that the consulate is probably not familiar with, then we would look for trade publications, for example, or any documentation that we can include in the application to convince the officer that enough money has been spent. To take a recent example, we had a client who was starting a tattoo parlor, and you know, we didn't know off the top of our heads how much it would cost to get a tattoo parlor started, so we knew a consular officer would probably not know. So we worked with our client to get published articles on how much it costs to get a tattoo parlor started. Other options are to work with a CPA, a certified public accountant, to get a statement where they review what's been spent on the business and actually sign a letter explaining that they have reviewed the amount and that it's sufficient to start the business. Number two on the screen, you see the business cannot be marginal. We'll also talk about this more later in the presentation, but this is really a fundamental requirement. The business must generate enough revenue so that it can support US workers. It must be able to support more than just the applicant and the applicant's family. So you do have to show that over the course of about 5 years, that the business will employ, we recommend, between 3 and 4 full-time equivalent US workers. That means anyone who's legally able to work in the US. And again, that's within a 5-year timeframe. We'll talk about that more later in the presentation. The business must be real and operating, and that means that essentially the consulate will want to see that once they issue the visa, the applicant is ready to travel to the US and hit the ground running. They're ready to start generating revenue, hiring workers, and really get the business operational. The E-2 visa is not a visa that's meant to allow someone to come to the US and at that point start looking for a business opportunity. The business really should be ready to operate when the visa is granted. And there are certain ways in the application that you'd show this. You'd include certain evidence, such as a signed commercial lease, that you have space that's ready to be filled with equipment, inventory, employees. You'd want to show that the business has been established in a specific state in the United States. You would also want to include, if you have it, screenshots of your website that you're already marketing. And there are other things. If you have a business that requires a license, for example, a pharmacy, you'd want to show that you have the license that's required to operate the business. And if it's necessary, this next item is really, you don't see everyone having it, and for some businesses it's not possible, but if you do have contracts with customers or letters from prospective customers that says, once the applicant gets their business going, I will certainly hire them to do this project. Showing the government that there already is an interest in the business can be important for certain applications. The fourth requirement on the screen is that you will be coming solely to develop and direct the E-2 enterprise. So there are a few aspects to this. First is your job, if you get the E-2 investor visa, is to be an active participant in the business. You need to be coming to the US primarily to manage the business and to grow the business. Related to that, you need the necessary background to do that. So part of the application is showing the government that, for example, if you're coming to start a pharmacy, that you have the necessary training and education to run a pharmacy. For many businesses, there's no specific background that's required. So what we would do is really use the applicant's background and really kind of advocate for that person and say, based on their resume, that they have the experience to manage a business. Fifth requirement is really one we see, we discuss a lot with clients, is that the E-2 investor applicant must own at least 50% of the business, and that ownership percentage cannot drop below 50% at any point during the visa, while they have the visa. If they, for example, sell equity and their ownership drops below 50% to 49%, they would become immediately ineligible for E-2 status. So that is a very important requirement to maintain. The flip side of that is that it is possible to have a 50-50 ownership arrangement with another owner, and they can also apply for an E-2 investor visa, but you must own at least 50% of the E-2 business. And finally, you must have the intention to return to your home country upon expiration of the E-2 visa. This is because, as you saw on the first slide, the E-2 visa is a non-immigrant visa. That means it does not lead to a green card, and it is not intended to allow people to adjust status to a green card. Really, it is important when you're applying for an E-2 visa to convince the government that when your visa expires and your status expires, you will return home. Usually this doesn't play much of a role in applications. What we would include is a signed statement signed by the applicant that says at the end of the visa period, I plan to return home. So let's talk a little bit more about how much investment is enough. If you recall on the prior slide, the investment into the business, the E-2 business, must be substantial. Now, what does that mean? The government does not establish a specific dollar amount. The government never says, if you invest $1 million into an E-2 visa, you've satisfied the requirement. Instead, what the government will do is they'll look at the type of business and they will ask, has enough money been spent on this type of business to make it operational? Let's take two examples. Our law firm was founded on an E-2 visa. A law firm does not require a lot of money. You need a small office, a computer, a couple of computers, maybe insurance, a phone line, a website. So the investment amount in our law firm could be quite low, could be in the range of less than $100,000, which we would consider a relatively low investment amount. And the government would look at that and would say, and did say, this is a law firm, doesn't require a lot of money. The applicant has spent enough to make the business operational. On the other hand, if you are trying to start a business that is manufacturing batteries for electric vehicles, a lot more money may be needed before that business is operational. So that kind of business, depending on the nature of it and the specifics, the government might say, well, you've invested $1 million into this business. Typically $1 million would be fine, but to go with the example, a manufacturing company may require more, and likely would require more investment amounts. The government would want to see more in order to satisfy the substantial investment requirement. Keep in mind that consulates do differ on this. So certain consulates want to see a higher investment amount than others. For example, Japan sees a lot of very large businesses, so that consulate might want to see a larger investment amount versus some other consulates. And This also, the overall investment amount, it doesn't it isn't looked at in isolation, meaning the consular officer will look at the entire application and will consider whether the investment amount is sufficient. We have an entire presentation on low investment and risky cases, so I would encourage you to either sign up for that webinar in the future or watch it on our YouTube channel. But the takeaway there is that if you if other aspects of the case are weak, for example, if it's hard to show that you'll employ workers, you may want to bolster your investment amount, and vice versa. If you have a low investment amount, it is especially important to show that you're likely to hire workers or already have. This fourth bullet on the proportionality test, that's what the test is called, that the government applies to determine whether you've invested enough in the business. And to show, how do you show that you've invested enough? Well, you could show it through what you're seeing on the ground. So for example, if the business is already operational and you've spent, say, $50,000 on the business, it's been operating for a year, it's already generated revenue, you would include your tax returns, you would include any payroll records showing that even though you've only invested $50,000, this is a business that is already operating and generating revenue. If you don't have that, you could turn to a CPA, and like I said before, have a letter that substantiates that. Again, buying a business is an option. You don't have to start your own business. If you're buying a business, then the investment amount is typically what was paid for that business. The government will understand that if a business was purchased on the open market, then that by definition is the fair market value. So you would want to show what you paid for at least 50% of that business, and that's usually sufficient. Franchises are a good option for E-2 visas, and franchises will often have their own pay structure. You have to pay a certain amount within a certain time frame, and that's usually fine. You would show the consulate that you're complying with the franchise agreement, and the same rule would apply, that the government will want to see that franchise is ready to be operational when you arrive. But if there are certain things that you're not able to do before you get into the US, consulates can be understanding if you show that you have an investment timeline that's compliant with the franchise agreement, and when you get to the US, you'll complete that obligation to invest in the business. And there are common good and bad E-2 visa expenditures. We already went over some good ones: inventory, equipment, paying for an office lease, paying for workers, whether independent contractors or full-time W-2 employees or part-time W-2 employees. Bad expenditures tend to be if you're traveling to the US to look at business opportunities. We would not encourage you to include those expenditures. Tuition payments to get a degree, we typically would not include things like that. Really is a case-by-case scenario, though. Do I have to hire employees? The answer is you must hire employees by the time you renew the visa. So it is not necessarily necessary to hire employees before you apply for the E-2 visa. But the E-2 visa is only granted if the consulate is convinced that your business will employ between 3 and 4 full-time equivalent workers within a 5-year period. So this is called the marginality requirement. And you do need to show the government that you'll be able to do this. So how do you do that? Well, if you're purchasing an existing business, it can be very easy to show that your business will employ 3 to 4 full-time employees. You would show that the business has already done that. So if you're buying say a convenience store, you would try to get the payroll records or the tax returns for that business that shows the amount of compensation the business has already paid. And that would be generally sufficient to show that you meet this requirement. If you are starting a startup, it can be a little different. That points to the importance of a business plan. A business plan will show financial projections over a 5-year period, and will also show employment projections. So through the business plan, you'll be able to say, consular officer, in year 1, my company will generate this much, years 2, 3, 4, 5. and I will be hiring this person in year 1, this person in year 2. And that's really why a business plan is especially essential when you have a startup versus when you're starting a new business. In terms of W-2 employees are ideal. Those are employees versus independent contractors, who we refer to as 1099 workers. That's just the tax form. The government will consider both as persuasive. It's better to have W-2 employees versus independent contractors. However, if you only are having 1099 workers at your business, it is possible to apply with that for a renewal. Now, for an initial application, if you only have a 1099 worker, that's great, because keep in mind that a lot of initial applications have no workers. And again, you can rely on projections for the initial application. So we talked a bit about how do I prove this, so I'm not going to spend much more time on that. Business plan considerations. I also referenced this in the prior slide. Business plans are especially important, essential for a new business. For an existing business, if you're purchasing it, they're less critical. They would also be important for a franchise if you're starting a franchise, because a franchise hasn't been existent. So there's no tax records or payroll records that you can refer to show that it satisfies the marginality requirement. What should the business plan contain? Keep in mind that this is a business plan that it should be targeted to a consular officer. So there are a lot of firms, businesses that prepare business plans, but they are not meant for consular officers. The questions that a consular officer will want to know are fundamentally, is this a business that within 5 years will generate sufficient revenue to employ 3 to 4 full-time equivalent workers? And you really want your business plan to really answer that question directly. In terms of the time frame, we would usually recommend that you start hiring in year 1. If that's impossible, it is possible to start hiring in year 2, so long as you show that by year 5, you really do have those 3 to 4 full-time equivalent workers. So the business plan should have an executive summary. Oftentimes the officer will not get past the executive summary. They don't spend a ton of time on applications usually. So you want to put the key information at the very beginning in the executive summary. Market analysis and research showing that you've thought about your competitors and you've thought about the size of the market. A marketing plan about how you're going to grow revenue. A personnel plan that shows that you'll hire those workers within 5 years. Comprehensive financial plan showing that your revenues will support that personnel plan. And do I need to hire a professional? The answer is no, you don't need to. We do have clients who prepare their own business plans, but the important thing to keep in mind is that this is a document, again, that is meant to convince a consular officer that you should receive a visa. It's not necessarily a typical business plan that you would use, say, to encourage outside investors to invest in your business or whatnot. So if you are going to prepare it or hire someone to prepare it, make sure that they're keeping the consular officer in mind as the intended audience. And with that, I will pass it off to Kelly to speak about E-2 visa developments and adjudication trends.
Thank you, Dustin. And I think there's several kind of questions that have come in, some of which we'll address later in the presentation and some of which we'll kind of answer at the end. So if you've written in your question and we haven't answered it yet, we'll get to it towards the end. So switching to E-2 visa developments and adjudication trends. On the issue of investment purchases in the US, this is a common question we get, do you have to make all of your investments in the United States? And there is no requirement in the regulations or the law that you have to make your investment in the United States. So for example, if somebody is starting a business that has inventory they purchased from abroad, that purchase of that inventory can certainly be, an investment expense. That being said, we are seeing a trend over the past several years of officers sometimes asking about this and asking how much money was actually spent in the US. So even though it's not a requirement in the law that you have to make your investment in the United States, the purpose of the E-2 visa is to facilitate, kind of an economic exchange and benefit between the treaty country and the US. So it is beneficial to make at least some of your investment purchases in the United States. to use US vendors, if at all possible, and have at least some of your investment, be made in the US. So another, kind of issue, administrative processing. So this is something where when you go to your E-2 visa interview, usually you'll be told at the interview whether your visa is granted or not. Sometimes if the officer wants more information, they may put your case into something called administrative processing. This is where you'll get something called Form 221G. It is a technical denial. So if you're from a country that permits ESTA, it does count as a denial for ESTA purposes, which means that unfortunately it could impact your future eligibility for ESTA. If you receive a 221G and your case is put into administrative processing, you may get instructions from the consulate as to what additional documents they'd like you to submit, or they may just need more processing time. So for example, you have a complicated criminal issue, sometimes they'll issue a 221G if they need to kind of go and assess, whether there's eligibility or whether a waiver is needed. Additionally, it's also possible that when you're getting your visa, even if they say it's granted, sometimes cases can be put into administrative processing, later. What can happen is that any government agency can flag a visa petition for further processing, not just Department of State. So when you're processing a visa, Department of State is processing your visa. But if another government agency flags your visa application and says, we need to put this on hold, we're looking into this, there's really nothing the Department of State can do at that point. So it's just to say it's I think not that common, but certainly in the last administration, we saw a big uptick in administrative processing requests, often particularly related to kind of extra security questions. So it is something to be aware of, and you always want to make sure you're going through, a complete immigration history with your attorney. Sometimes if you have prior, maybe prior immigration petitions or a pending immigration petition for a green card, if you have any criminal history, these things can all kind of flag these additional security questions, travel to certain countries where there's additional security risks. These are all things that can indicate, potential administrative processing. So something else that's been happening lately are an increase in USCIS filings. So, because of the impact of the pandemic and the ongoing issues with, availability for appointments for visas at consulates and reluctance to travel because of COVID, more people are filing with USCIS. So, it's possible if you're in the US, for example, if you're here on, B1 business visitor status or even B2 tourist status, you can change your status to E2 status in the United States. Additionally, if you have your visa already, but you don't want to travel or you can't get a visa appointment, you can also extend your E2 visa from within the US. There's a few key differences with a USCIS approval. So rather than a visa, a USCIS approval is for 2 years only, always. And you cannot travel internationally using that approval. So if, let's say you get your USCIS approval, once you leave the United States, you would need to go to a consulate and get a valid visa before you'd be able to re-enter. And it's when I say get a valid visa, I mean, you'd have to present a brand new visa application to the consulate and they would review it as though it was a brand new visa application. They don't have to defer at all to the USCIS approval. So that's something to keep in mind. Another thing that's different about USCIS filings is USCIS is generally more lenient on the investment amount. So they're more willing to accept a lower investment amount, but they are extremely strict on other elements such as the source and trail of funds. So at a consulate, for example, if you are using your personal savings from employment, you may be able to submit just your tax returns, and proof of you transferring money to your business bank account. With USCIS, they may want to see, the actual money, the payroll hitting your bank account and accumulating over several years, and then the money being transferred. So they are quite strict on that. Additionally, for the requirement that you develop and direct the business, I know Justin mentioned, it can be helpful to show you're going to hire an employee in year one. For USCIS, they often will challenge, if there are no employees in year one, they may challenge the investor and say, well, are you really doing primarily, developing and directing activities? Are you doing kind of skilled labor? So for example, if you were a chiropractor and opening a practice and you were the only licensed chiropractor, you'd probably want to hire another one, to help show that you will be doing kind of the high level duties, and you would have someone else to be doing more of the skilled labor for your business. All right, so, the impact of the Biden-Harris administration, we're now, in 2022. And I think, we didn't anticipate any major changes to e-visa adjudication. And, as we expected, we haven't seen any changes to e-visa adjudication. There really weren't large changes to e-visa adjudication in the previous administration either. I mean, obviously, there have been changes to adjudication because of the pandemic. In the sense of visa availability or visa appointment availability is less. But in terms of, what's going on with, the political situation in the United States, it's not impacting e-visas. So let's turn to kind of COVID-19 issues. So it is another thing to consider when you're thinking about, kind of traveling to the United States. So even after you get your visa and you have your visa and your passport, you want to travel to the United States, you should consider what the current requirements are to enter the United States. So just the fact that you have a valid visa doesn't kind of exempt you from those requirements. You always want to check the CDC's website for the most updated guidance. At the current time, you must have proof that you're fully vaccinated and provide proof of a negative COVID test taken within 1 day. And that's for kind of anyone trying to enter the United States. So something to keep in mind, that just because you have your visa, it doesn't change those requirements for you. In terms of consular issues, timelines to get a consular appointment are, much more varied perhaps than they used to be. So, there used to be many consulates where you'd have, a real set timeline. In Canada, you'd submit and within 10 days, you get notified to make an appointment, and then you might get your appointment within 2 to 3 weeks. It's much different now, where it could take several months for them to call you for the appointment, and then maybe, a bit longer to get the appointment. And it's really, I'd say, very different based on the different consulate. So every consulate, was kind of given permission to restart their visa processing under the timelines that worked for them. And so you really see a lot of variation across consulates right now in terms of, what availability they have. So there's certain consulates like Frankfurt where they're reporting really that they're processing, on normal timelines, right now. Whereas there's other consulates, particularly ones that have facilities that don't allow for social distancing as easily, or kind of smaller facilities, some of the consulates in Italy, and in Dublin, and those are having a harder time kind of catching up with the backlog. So if a consulate has a smaller staff, sometimes it can be more difficult especially if it's a high volume post for visa processing or other services, but they don't have a lot of staff. So it is something to keep in mind, when you're planning. I know a few people kind of wrote in talking about long consular delays and how that complicates kind of purchasing a business, and we'll talk about that a bit more later. Ultimately, there's, I'd say, little to do with the consular issues other than kind of wait for them to slowly resolve. Everything is, for consulates, is really dependent on the situation on the ground. So if they're, consulate in Italy, they need to follow the Italian government's, COVID protocols. So it's just something to kind of, you want to continually kind of see where things are at the consulate that you're applying at, because things can change, very quickly. Perfect. So issues and complex areas for E-2 visas. So source and trail of funds, I think, can be a complex area, particularly for USCIS filings. So, as I mentioned previously, they really are looking for a dollar for dollar accounting of exactly where the money came from. So if you received a gift from a family member, that's certainly permitted. That being said, it's not enough to just provide a gift letter. You have to provide the gift letter and then an explanation of where the money came from, and then supporting documents to show where that money came from. So for example, if your parent sold a property and then gifted you the money, you would need the purchase sale agreement. You would need proof of that money entering your parent's bank account, and then proof of that money being transferred to you, and then that money going to the business bank account. So you would really need an exact trail of exactly where the money has been. If people are kind of getting gifts and the money was just sitting in a bank account and, was earned many years ago, sometimes that can be quite difficult for USCIS. That being said, for most consulates, the focus is really not on the source and trail of funds as long as there's a legitimate explanation. So you can usually kind of submit with much, they don't focus on it nearly as much as long as there's a legitimate explanation and you can provide some documents, and you're not going to have to do that dollar for dollar accounting that you do with USCIS. Something else to note about the source and trail of funds, if you're getting your source of funds from a loan, so that is permitted as long as the loan is not secured by the assets of the E-2 company. So that is not permitted. If you're taking out a personal line of credit or you have a home equity line of credit, those things are fine. But you cannot take out a loan if it's being secured by the E-2 business. Another area that comes up a lot are kind of small investment amounts. Some investments are just going to be too small. For example, $10,000 is really never going to be enough. If you have a small investment, and when I say small, I mean under 100,000. I think it is possible to get the visa still. I think somebody asked a question about investing $50,000. I think in the Caribbean. So we certainly have had success with that, but it is based on several things. Such as what type of business are you starting? Are you starting up? Is it like, as Dustin mentioned earlier, like a law firm where there's really very few startup costs, and you can reasonably argue that if you spent $50,000, you've spent everything necessary to get the business up and running. So if you have an investment amount like that that's lower, it can work, but you need to make sure that all other elements of the application are very strong, and you need to include supporting documents to prove that you've really spent everything necessary to set up the business. So for example, if you were setting up a business with a lot of large fixed costs, like a car manufacturer, you would have, I think you would really never be successful with a $50,000 investment because it's just not enough to get everything that you need to actually get that business real and operating. And if you're looking at a small investment amount, you also want to make sure that all other parts of the application are strong. Make sure you have good proof of real and operating, that you have a strong detailed business plan. You may want to get letters from local business organizations or a chamber of commerce to support your application, letters of intent or contracts with future clients, and perhaps even have an accountant look over your business plan and your investment and maybe issue an opinion that you've spent everything needed to set up the business. So looking at E-2 visas for 2 investors, this is possible. It's a common situation. If you own a business 50-50, it's possible to each own as investors, but you do need to each invest money. Ideally, you're investing kind of an equal amount, but it's not always required, but does make the case more straightforward. Substantive changes to businesses after filing. So this is, I'd say, in terms of an area for the E-2, if there's going to be any changes in ownership structure, the company must still always be at least 50% owned by treaty country nationals. And if you are the investor, then you need to retain 50% ownership. So even after you get your visa, even if it's valid for 5 years, if your ownership drops below 50%, or the company is no longer owned 50% by treaty country nationals, this is a problem. And your visa can essentially become invalid, even if the consulate's not aware of it yet. Something else to consider is changes in your business type. So if your type of business is changing drastically, like for example, you have a consulting company and now you want to start operating a restaurant, you need approval before you can start that new business. So either you can seek approval from the consulate where you got your visa, you may need to submit new documents, or you can seek approval from within the US with USCIS. But the key thing is that you need to seek and get that approval before you start the new line of business. That being said, if your change to the business is not substantive, so if you are, you're a wedding photographer and you decide to start a wedding and photography blog along with that, that's really not considered a substantive change. You're still offering the service that you said you would offer, and you're just kind of growing the business. So in that sense, you don't need to get new, approval before you can kind of continue running the business. And if you do anticipate that you want to have multiple lines of business, you can contemplate that when you submit your initial application. So that's something else to consider. So family business purchases, someone had written in with questions about this. So yes, it is possible to make a purchase from a family member. That being said, it will be scrutinized more heavily. It's inherently more suspect, to the consulate or to USCIS. So there's some things you should do. For example, you could get a third-party valuation of somebody who's looking at the financials and issues a objective opinion as to what the fair market value of the company is. This is important because if you're buying from a relative, and the financials of the company are very high, but the purchase price is very low, they may not think it's substantial. Additionally, if you're doing that, you want to make sure there's a really clear source of funds. So, you can't be purchasing a restaurant from a family member and that family member is gifting you the money. That would never work. So you just want to be careful when you are, yes, it's possible to purchase a business from a family member, but it's going to be a riskier application, and you definitely want to have objective proof that you've invested a substantial amount, because it won't really be like a fair market value of a business on the open market. All right, so common reasons for E-2 denials, so one is low investment amount. If the investor has more money, this can be relatively easy to fix because you can invest more and reapply. You could also gather industry evidence to support that your investment amount is substantial in relation to the total cost to set up the business. You could have the CPA review the business plan and the expenditures and write a letter, as I mentioned previously. So nature of the business, real estate, is very risky. There's just certain types of businesses that are riskier. Consulting companies are often risky. The officers sometimes can be concerned in that case, for example, with a consulting company, that someone's just going to come in and act as a solo consultant. And that's really not what the E-2 is for. The E-2 is for people that are going to run a company and hire US workers. So if you have kind of a business that has one of these riskier types, there's some additional things you want to do. For example, hire employees before you file. Get proof of contracts to show that you're not going to be just kind of, that you're going to be working for multiple people. If you're doing real estate, you cannot really just be flipping houses unless you're doing it on an extremely large scale. And we do have separate webinars that address in particular these risky types of businesses. So I encourage you to kind of look for those on our website as well. So filing locations or venue, some consulates are more E-2 friendly. They do lots of E-2 visas. They're familiar with the requirements. Toronto and London are two good examples of that. USCIS, as another venue, has, pros and cons. So, pro is they're okay with lower investment amounts. A con is they want that dollar for dollar accounting of the source and trail of funds. If another kind of common reason for E-2 denials, if you have a business in your home country that you've been running for a while and it doesn't have any employees, they may, your work history is going to be disclosed on your DS-160. It's also usually on your resume to show you can develop and direct this type of company. The consulate may look at that and say, we see a business plan, but we don't believe you're going to hire employees. You've been running the same company for 10 years and you have no employees, or you've just employed you and your spouse. Those types of things can create red flags, and those can be harder to overcome because, it's kind of the officer's subjective feeling is. So, for something like that, if they're concerned they're not going to hire employees, you could go back, hire employees, pay them for a while and reapply. So, similarly, concern over whether the business will create jobs for US workers. This is just a big, a big part of the E-2 visa is showing that the company is going to support more than just the investor. So again, an easy way to kind of address this is to hire an employee before you file if you think there's going to be particular scrutiny on that point. Issues with an adjudicating officer, consular officers, by and large, are very polite and professional. That being said, there can be instances where they perhaps are not as familiar with the regulations, or you have an unpleasant experience with an officer. Unfortunately, they do have complete discretion over whether to grant or deny the visa. There is no kind of appeal process. However, getting a denial doesn't bar you from reapplying. So you can always reapply. And most consulates will make the effort to give you a different officer. If one officer denied you, they will usually try to set you up with a different officer, although there's no guarantees of that. So if you did not meet the requirements at the time of filing, a poor file that didn't include what was needed. So for example, we had a client who came to us after they filed their own case and were denied. They had spent $2,000 and put $98,000 in a business bank account. So they just clearly did not meet the requirements. They had not invested enough. Their investment was not at risk, irrevocably committed. So we advised them on things they could do to spend, the necessary funds to invest, to get the business to be operational and to make a substantial investment. They went back and they were approved. So that's something that can be remedied, even if you initially submit with a file that isn't found to be, meeting the requirements. All right, so what does it take to renew an E-2 visa? So I know we've said this over and over. Hopefully it has sunk in by this point that hiring US workers is key. You want at least 3 full-time equivalents in 5 years. Salary doesn't matter, but I will say that, if you have 3 employees, it really is full-time. So if you have 3 employees on your W-2s and they've been paid each $6,000, it's pretty clear that's part-time. They're not making even minimum wage. So you do want to have kind of full-time employees, but if they're full-time and making a lower salary, that's okay. You want to, provide updated financial data. So they're going to look at usually tax returns for at least 2 years. When you submitted your business plan, if you exceeded what you submitted, then you can, show, yes, we met or exceeded our revenue targets. That's great. But if you didn't, that's okay as well, as long as you're still, making enough revenue to be, to kind of keep the company running and to pay your US workers. So is the company profitable? Definitely, a net profit is much better than showing a loss. If there are kind of small losses and they're explainable, kind of for tax issues, I think that's generally fine. Again, as long as you are still able to kind of keep the doors open and pay your US workers. So they're going to want to see payroll information, W-2s and 1099s. If you kind of hire any new workers, you can include payroll summaries as well. It can be helpful to kind of speak to how did your marketing and sales plan work? Have you had any good business accomplishments, signed any really lucrative contracts, received any great reviews? For example, if you're a restaurant, those types of things are all really helpful, to show that the company is successful. So any large client signed, any positive online reviews, if you've expanded your services, if you've invested more money because you've, opened a new location, those are all really positive, signs for renewing the E-2 visa. If the company is not doing well at the time of your renewal, you can submit another business plan that shows, your plans to kind of get yourself back on track. And if there was kind of a slow, or short downturn, for example, in 2020, I think, but the company had otherwise been doing well and now you're on, a path back to recovery, I think, that can still be an approvable renewal. You just have to do a bit more work to show it's really a viable company. In terms of renewing, does the company still meet the E-2 requirements is really key. So if there, as we discussed, an investor needs to own at least 50% of the business. And treaty country nationals need to own at least 50% of the business. So if there's been any changes in ownership that would change that eligibility, that could potentially be an issue for renewal. And similarly, the changes to the business we discussed previously, so the company should still be providing the services it represented in its initial application. It's okay if it changed due to market forces, like let's say you had a marketing company and your niche was going to be healthcare, but instead you got a lot of clients in finance. That's fine. You're still providing marketing services. If the business line changed entirely, like we talked about, a consulting company to a restaurant, that's the kind of thing that would be an issue. So I think now we can turn to some of our questions.
Yes, we have had a number of questions come in. I think the questions are great. Kelly, I don't know if you saw any in particular. I'm happy to dive in.
Yeah, why don't you go ahead and dive in? I think we'll say there's some that are extremely long, and for people, we're happy to kind of provide general comments to the extent we can, but for people that have really specific questions that are not going to be applicable to the group, please feel free to set up a consultation with us, and we're happy to kind of go through your specific questions at that time.
Perfect. So I know there's a theme of questions that focuses on delays at the consulates, and Kelly talked a bit about this during her presentation. Certain consulates are extremely backlogged. Rome is one that comes to mind, where it could take a year or longer from the date of submission of the application to actually getting your visa. While other consulates seem to be going much faster. So what can be done there? So this does depend on the consulates that are in question. Certain consulates do accept applications from third country nationals, so people who are citizens of other countries. But you do need to find out if the specific consulate that you're looking to go to will accept an application from a third country national, especially if you have no ties to that country. So if you have, say you live in Italy, but you have a passport from Germany, a German passport, it may be possible for you to go to Frankfurt for an interview and get a faster interview date. Or if you are a national of Colombia, which the Bogota consulate is also frozen when it comes to E-2 applications, but you're working in Mexico as a temporary resident, you very likely, and I know for a fact, you could go to Mexico and get an interview there much more quickly. So the question is, do you have ties somewhere else? And is the consulate in the other location accepting third country nationals? The other thing to consider is that in some cases, it can be possible to file a change of status application within the United States. So if you have a legitimate reason to come to the US or an existing visa, say a B1 visa or another visa, and you are able to spend 2 or 3 months in the US and then change status within the US, that could be an option. But you do want to be careful to not commit misrepresentation by coming in on one visa and immediately changing status. So you'd want to be careful of that. Kelly, were there any other questions you wanted to turn to, or do you want to just go down the list?
Yeah, I think we can just go down the list. So I think you talked about the delays. Someone's asked a very long question about kind of USCIS and the I-129s and the I-539s. So basically, if you file an I-539 with an I-129, the children are allowed to stay for as long as the I-539 is processing. It is not possible at this time to expedite the I-539 process. The best time to apply for renewal inside the US is just gonna, before your status expires is, I think, a blanket answer, but will kind of depend on your circumstances. And then if you hold a single entry E-2 visa, can you travel to Canada and Mexico and come back? Potentially, yes, under something called automatic revalidation, but it's specific, more specific to circumstances. If for any reason the business doesn't go as expected, but my E-2 investor and I decide to change the business, is the visa renewable? Potentially, but probably if you're going to change the business, it's not really a renewal, it's more of a new visa application. All right, so.
Yeah, I saw Mitesh asked a great question that is it possible to change from E-2 to a green card? The answer it is possible through adjustment of status. However, it's very important to know that an E-2 does not lead to a green card. You basically have to, you get a green card by satisfying the requirements for that specific green card. So for example, if you're in the US on an E-2 and you marry a US citizen, you could become eligible for a family-based green card. If you're in the US on an E-2 and you build the business and invest the necessary funds into it and create 10 jobs, you could be eligible for an EB-5 visa. So it is possible to adjust status from an E-2 to a green card, but the E-2 does not lead to a green card. I know that's a subtlety and can be hard to understand, but fortunately, we have an entire webinar on exactly that question. So do check out our YouTube channel where we've posted that presentation. And I think we will be giving it again in the future. So check it out on our website if you want to attend live.
Yeah, absolutely. So a couple more, I think, quick questions. One, someone asked if you change the legal form of your company to LLC to Corp. Is that a substantive change that you need approval for? It's not. That as long as you're kind of continuing to do the same thing and you're not shutting down your LLC and changing, starting a new corporation, as long as you're converting, that's fine. It's not something that's considered a substantive change. Some consulates, such as, ask for updates. Toronto, I think, is one of them. But most consulates are not asking about that. Someone also asked, they're an E-2 employee, what happens for the visa if the E-2 employer receives a green card? So once somebody becomes a green card holder, they are no longer considered a treaty country national for purposes of the E-2. So that is a problem. If there's a company and the one E-2 investor becomes a green card holder, the E-2 employees are no longer in status and are no longer able to use their visas. Someone's asked about kind of their specific circumstances for the renewal. I would encourage you to kind of set up a consult with us, because it's just not it's not something we can answer from kind of this this circumstance. It looks like it would be difficult. It looks like it would be difficult to renew, but again, I encourage you to set up a consult, because it's very specific, detail specific, and we have been able to kind of obtain success for renewals, when there's things you can do to make it stronger. Let's see, can a TN visa holder apply for a change of status to E2 while TN is valid visa in the US? Yes, you can. That is possible to do. Can my wife still work with an E2S status after the visa is expired? So the visa, as I think Dustin mentioned, is an entry document. Once you get into the US, you get an I-94, that's your status. As long as the status is still valid, then you can work. If the status is expired, then you cannot.
And the only other thing I'd add to that is that the rule on spousal work authorization changed earlier this year. So there's also automatic extensions of work authorization if you file the renewal in time for work authorization, and if you have a valid I-94. So check out the rules on that online, or reach out to us if you want to speak further about it. But the rules have become much more generous toward
Yes.
E2 spouses.
Absolutely. And someone asked if their E2 visa divorces, will a spouse lose their visa? So yes, so the dependent visa is dependent on the marriage relationship. If that ends, then you cannot, you can't keep your dependent visa. Can you split the business and each get a visa? Potentially, yes, you would need to, each meet the elements separately and apply for new E2 visa applications. If the E2 spouse can find a job and get sponsorship, can this lead to a green card? Yes. As Dustin mentioned, if you're eligible for a green card separately while you're on an E2, you can apply for one. So if you're on an E2 and a company wants to sponsor you for an EB2 or EB3, they certainly can do that. Let's see if there's any other final questions.
Only other question, another just came in, but the other question I see is, I'm thinking of setting up an LLC and get an EIN, employer ID number, tax ID, so I can open up a bank account. I do not know the business name yet. Would that be an issue? Not necessarily. I mean, you can change the business name without fundamentally substantially changing the business. I mean, for simplicity, it is certainly easier if you have the business name set and everything is aligned, the bank account, the LLC formation, all that. But if you need to operate under a different name, that's usually not an issue for an application.
Perfect. Yeah.
Oh, go ahead, Kelly.
Someone just wrote in about L visas. You can add up time not spent in the US during the life of the visa. Is that something you can do? Yes. You can submit something called that's completely different than kind of what we've been talking about. But for the L, yes, there's a 7-year maximum for L1A, 5 for L1B, and for time spent outside the US, you can submit something called a recapture petition to get that time back. It's not relevant to E2s. So I think that is everything. And so thank you all so much for your questions and for your participation. Dustin, thank you so much for sharing your knowledge. And we wish you all a great day.
Thank you so much.